All right, folks, conservatives, Republicans have been doing all they can to get rid of the Voting Rights Act because they do not like black power. Well, the Eighth Circuit today issued a ruling that is unbelievably illogical. They actually ruled that only the Department of Justice can file lawsuits using Section 2, not individuals, not organizations. Do y'all realize the DOJ has filed less than 20 cases, but outside groups have filed nearly 200 in the last several years? Let's break this thing down right here, folks, with my panelists. Kareem Creighton, Senior Director of Voting Representation at the Brennan Center for Justice at NYU Law School. Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Damon, I want to start with you. This was a 2-to-1 vote by a 3-judge panel. Clarence Thomas has been wanting to get rid of the Voting Rights Act. Republicans have been targeting Section 2, and it's under Section 2 we've been able to get those congressional districts in Louisiana, in Alabama. What do you make of this decision?
Well, Roland, it's a classic case of a right without a remedy is no right at all. That's essentially a translation. This is not a new play, this notion of this so-called lack of a private right of action. You know, for the last 22 years, we've been living with this under Title VI of the Civil Rights Act, where the Supreme Court determined that under Title VI of the Civil Rights Act, which of course prohibits entities that receive federal funds from discriminating based on race, that there's no private right of action there as well. And so the irony is really like patent. The same court, the same people that told us, oh, it doesn't matter that we gutted the heart of the VRA with Section 5 in Shelby County v. Holder in 2013, you still have Section 2. Now, Roland, we've known all along that Section 2 cases are more expensive, more fact-intensive, more time-intensive, and sometimes when you win a Section 2 case, bad things have already happened, just like in Alabama, right? A whole election has gone by. But now they're telling us Section 2, forget about that as well. This is the play, and this is evil at work, quite frankly.
That's exactly what it is, Kareem. And again, there are people out here, and I've been doing what I call Civics 101 on social media because a lot of our people don't quite understand what conservative Republicans do. They file cases hoping they're going to make their way through the court system and get to the Supreme Court, where they have 6 conservative justices on the Supreme Court, and all they're hoping for is for 5 of them to side with them that would invalidate Section 2 of the Voting Rights Act. And if that happens, Section 4 has already been gutted. You gut Section 2. Oh, the attack on black people is going to be all over the country.
I can't question anything you said there. Section 2 has traditionally been viewed as the sword that plaintiffs have to go and defend and vindicate their right to vote. As Damon mentioned earlier, it's been really an opportunity that has worked in really episodic ways, not as perfectly as we'd like it to, but it has worked. And I think that there are people out there now who want to get rid of it. And the court told us in 2013, as Damon said, look, we've got Section 2 of the Act still on the books that will allow plaintiffs to go in and sue. And that's really the world that has existed since 1965, when Congress observed the fact that the DOJ wasn't sufficient to vindicate the right to vote throughout the country, and therefore created this statute. So all of the Congresses that adopted the act, all of the presidents that signed it, all the Supreme Court majorities that upheld the act would be shocked to hear that all of a sudden this question now is a live one.
Damon, the thing that, again, get people to understand how major this is. And I keep trying to explain to people why federal judges matter. We're not talking just about congressional races. We're talking congressional races, state races, county districts, city, down to county commissioners. We just had the courts rule in favor in a case in Galveston, Texas, where they redrew the lines when it came to county commissioners. We're talking about the representation of black people and others up and down the ballot all across the country, especially in the South.
That's exactly right. There's levels of bad here. So when you think about Bush v. Gore after the 2000 election, where the Supreme Court essentially helped determine who will become president, you think about congressional races. But then you think also about the races at the state level, the local level. Think about all of the things that we've gained. The Milligan case in Alabama, which was a win, that would not have been possible based on this ruling. Louisiana getting another black congressional district, that would not be possible under this ruling. The Congressional Black Caucus is the largest it has ever been in this Congress. That would not likely have been possible because we know some of those districts were created because of the Voting Rights Act, because of enforcement of the Voting Rights Act, not just by DOJ, but by private litigants. What they're saying is you people, black people, don't have rights that this court cognizes. It kind of rings, I know it sounds hyperbolic, but it sounds like Dred Scott, no rights which they are bound to respect. That's what it feels like in the sting of today.
Kareem, again, we hope the courts will use some sense. The decisions they have recently made with regards to Section 2 in the Louisiana case and the Alabama case have been positive. But as I said, all they need are 5 votes. And what people need to understand, when one of these circuit courts or lower courts makes one of these decisions, it literally can imperil, again, the entire law. And once that happens, now all of a sudden, we're going back to, frankly, all the battles from, frankly, the 40s through the 50s through the 60s just to get the Voting Rights Act.
That's right. And it's important to know that as of today, this decision applies to all of the states in the 8th Circuit, which goes from as far north as North Dakota and Minnesota down through Arkansas and Missouri. And these are places where there are a lot of people of color bringing claims. I would say also it's important to know that as we're talking about it, there are a lot of cases out there that are pending. There's a case just today that Native American groups won under Section 2 in North Dakota that now people have to ask, do we have still a live win? We may win, but we may have to now fight this question about a private right of action. But I think your point about the disrespect, and that's how I look at it, for all of the accomplishments of lawyers like the Lawyers Committee, like Legal Defense Fund, that have gone in and followed through on the call that Congress made as early as 1965 to make sure that in each one of these jurisdictions that are not paying fair attention to the right to vote, particularly for people of color, that there is vindication for that violation. And it's important to know that, in addition to redistricting, which obviously has a huge impact on opportunity, there are a lot of suppression laws, access to ballots, making sure that people actually count votes appropriately. All of these things that make sure that the elections run the way that they're supposed to run and don't unfairly disadvantage people of color. We're on the precipice of a 2024 election. All of those things are subject to review under Section 2 right now, and they're usually brought, as we've said earlier, by private plaintiffs. So if we cut out the opportunity for private plaintiffs to go and sue, particularly for these last-minute gotcha efforts by states and local jurisdictions, we're kind of left open to real danger at having an election that's free and fair.
Indeed. Damon, final comment.
Well, look, what's not lost here, as you mentioned at the top, Roland, this was a 2-1 decision. The dissenting judge, although not as full-throated a dissent, but the dissenting judge was a George W. Bush appointee. That's what we're left to, folks. That's what we're left to in terms of who we have to convince on these federal courts. Now, we're a nonpartisan organization, so we'll argue any case, any time on the merits for black folks before these federal courts. That's what we do as lawyers and litigators, as Kareem knows and does well. But the politics have to sink in here, that if we don't care about the elections, then you're saying you don't care about the courts. And that's what you essentially saying, you don't care about your voice and your power, because that's what it comes down to.
All right, gentlemen, we appreciate it. Thanks a lot.